Hello and welcome to Impacts of the Tax Law Change on Wind Industry. Our webinar today is with STOEL RIVES in partnership with InfoCast Events. Today I have with me Kevin Pearson and Chad Marriott, who are both partners at STOEL RIVES. Today's webinar is a preview of what you can experience at InfoCast's upcoming Wind Finance and Investment Summit. That's coming up in early February in San Diego, California. At this summit, you can gain key insights on upcoming wind project opportunities and stay ahead of the wind market and get the best available outlook on the wind finance landscape with over 20 interactive panels and presentations on topics. We also have over 150 featured speakers, including speakers from EDP Renewables, Microsoft, and Tradewind. To learn more and to register, please visit www.infocastinc.com/win. Again, that is www.infocastinc.com/win. And before we get started today, if you have any questions during this presentation, please type your questions in the Q&A box in the lower right-hand corner of your screen. We'll make sure to answer your questions if time permits. Thank you so much, and now I'd like to welcome Kevin and Chad.
Thank you, Catherine. This is Kevin Pearson. Chad and I are going to talk today about some of the tax law changes that happened at the end of 2017, some that didn't happen, and basically what impact those changes have already had and will have on the wind industry, and in particular, tax equity financing for the wind industry and wind projects. We're going to start with just a very basic background of the tax benefits that are available for wind projects that will help frame the discussion of the changes. If you could move to the next slide, Catherine. So wind projects, and most people know this, so we won't belabor it, but wind projects qualify for, first of all, for one of two possible tax credits. The first is the production tax credit. It's a credit against income tax that's based on the amount of electricity produced and sold to unrelated people during each year of a 10-year credit period. The amount of the credit is it's adjusted for inflation each year. For 2017, it was 2.4 cents per kilowatt hour. We'll know what it is for 2018 in the spring. The credit period is 10 years from the date the project was placed in service. And this is interesting really only for illustration of one of the tax law change proposals that didn't happen. The production tax credit can be used against alternative minimum tax for the first 4 years after a project is placed in service.
Yeah, I mean, the only thing that I would add to that, Kevin, is for the 10 years from the date a facility is placed in service. So when we're talking about wind projects, each of the individual turbines is a facility for purposes of the PTC. So the typical PTC period would run from the date that the first turbine is placed in service until the 10th anniversary of the date that the last one was placed in service. So next slide.
So the other alternative tax credit, and you can't get both, but is the investment tax credit. And Congress changed the law several years ago to allow wind project owners to elect to claim the ITC in lieu of the PTC. The ITC, most people are familiar with it in the context of solar projects because those only qualify for the ITC. The ITC is a credit against income tax. It's based on the cost of the qualifying equipment included in a facility. Generally, that's 30% of the tax basis. The credit is claimed entirely in the year the project or the facility is placed in service. The ITC, although it's available in the year a property is placed in service, it's subject to recapture if the property is sold or disposed of or otherwise ceases to be used as energy property during the 5-year period after it's placed in service under a declining schedule. So if it's disposed of in the first year, there's 80% recapture, in the second year, 60%, and so on. So in that regard, it's sort of earned over 5 years. The basis of property for purposes of determining depreciation and gain on sale is reduced by half the amount of the ITC. So if a facility has a basis of $100 that qualifies for the ITC would be 30, and the basis of the facility for all other tax purposes would be reduced by half of that to 85. The ITC can be used against AMT without any restriction. It just can be. And property, of course, can't qualify for both.
And the use against AMT is going to be, that's another discussion point relevant to the new change, right?
So, yeah, so next slide. So the PTC and the ITC both are scheduled to phase out. And I'm sure everybody who's paying attention has followed this. Phase-out schedule has changed a number of times over the years. The PTC actually expired for 10 months in 2004 because they couldn't get an extension. This is kind of an unfortunate consequence of pay-go rules in Congress. But the current schedule is for a project to qualify for either the PTC or ITC, construction has to begin before January 1, 2020, and there's the phase down of the credit, whether it's the PTC or the ITC, based on when construction begins. And that's shown on the slide there. So if construction began in 2017, you get 80% of the otherwise allowable credit. And if it begins this year, you get 60% of the otherwise allowable credit.
So the thing that I would add to that, because I think most of the folks that are on the phone and listening deal both in the wind and solar world, this presentation is geared towards wind. So the phase out schedule that we've got on here is for wind. The ITC phase out for solar, for example, is different. You're going to have a step down from 30% that begins in 2020 and then hits a 10% plateau in 2022. It's also worth noting that the PTC isn't available for technologies other than wind if the construction commenced in 2017 or later. So no PTC for 2017 solar projects or geothermal or closed loop biomass or anything like that. So next slide.
So the phase down schedule is all based now on when construction begins, and anybody who's involved in development or investment in these kind of projects has dealt with this a lot. The IRS has issued a number of notices regarding what it means for construction to begin. There are two ways to begin construction. You can either start physical work of a significant nature, either on-site or off-site, or the owner can pay or incur 5% of the total cost of the facility, which is the 5% safe harbor. And whichever of those is used to meet the beginning of construction requirement, the taxpayer then has to either show continuous construction or continuous efforts after you begin, which is Congress's way of trying to prevent people from, or the IRS's way of trying to prevent people from digging a hole and then just stopping. Like, have you really started if you then immediately stopped? But these IRS notices create a presumption of continuous construction or continuous efforts if the project is finished and placed in service by the end of the fourth year after the year in which construction began. And that 4-year safe harbor or presumption has been very important in the industry because, everybody almost always relies on that for actually qualifying for the credit.
And that's for qualifying for the credit in the year that that was in place in the year that they started construction. Is that right?
That's right.
Yeah. So if a project began construction in 2017, it's going to be placed in service as long as it's placed in service by that same date 4 years later in 2021, then it would qualify for the 2017 PTC rate. Next slide.
So those are the credits. The other major tax benefits for which wind projects qualify or may qualify is accelerated depreciation deductions, which create valuable tax losses that investors may be able to use to offset income from other sources. MACRS for wind. MACRS stands for Modified Accelerated Cost Recovery System, which is just the modern form of accelerated depreciation. For wind projects, most property that's generation property qualifies for 5-year double declining balance depreciation deductions, which is very front-loaded. It creates very large deductions in early years. In addition, Congress has, over the years, allowed bonus depreciation for the year in which property is placed in service in varying amounts at various different times. Prior to the Tax Cuts and Jobs Act, which was enacted at the end of 2017, 50% bonus depreciation was allowed for projects that were in service in 2017. Then it was phased down after that. It would have been 40% in 2018, and so on. If a project qualifies for bonus depreciation, any amount that is not depreciated in the first year under bonus is then depreciated under the normal MACRS schedule.
Starting in the first year.
Right. So next slide. Now we're going to talk about with that background, the tax law changes that did and did not happen at the end of the year. Next slide. Given our time, I won't belabor this, but keep in mind when we're talking particularly about how tax equity investment document terms evolved, that President Trump was in his campaign promising broad sweeping tax reform. I think a number of people didn't think that would happen. And then he was elected to the surprise of many. And tax reform didn't happen for a very long time. We didn't even have anything in writing for a very long time, other than very, very vague
tweets
and whatever a white paper is. And then it all happened very, very quickly at the end of the year. So, and famously, I think the Senate voted on its version of the bill maybe before they saw it, but if not, very shortly thereafter. So a lot of this is all very recent, and everybody is still working through a lot of these changes. Next slide. First, some of the proposals that didn't happen that got a lot of press, particularly in the wind industry, and thankfully didn't end up in the final bill. The first one, the House version of the tax reform bill would have eliminated the inflation adjustment for the PTC. So the PTC would have been 1.5 cents. That would have been flat for everybody. It was very unclear from the proposed legislative language how that applied with respect to existing facilities. Nobody really knew if, to what extent it was retroactive. That didn't make it, thankfully. A huge change that was in the House version of the bill that didn't make it was a provision that would have appeared to eliminate the 4-year presumption for continuous construction. And again, that presumption was created by a series of IRS notices. The legislative language would have appeared to just invalidate those and would have appeared to require that you actually have a continuous program of construction and would have applied a facts and circumstances test regardless of when the project is placed in service. And that really worried a lot of people who had begun construction, let's say in 2016 or 2015, had taken a break and then were diligently working and maybe even were close to being finished and might not have qualified if that change had gone through. So thankfully that also didn't make it into the final version. And finally, this one I think caused a lot of confusion among people, but one version of the bill would have reduced the corporate tax rate to 20% and would have retained the corporate AMT, which is 20%.
Senate version, I think.
And so the result of that would have been every corporation would just be subject to the AMT. And that means that unless you can use the tax credit to offset AMT, it would have been wiped out. And so this didn't impact the ITC because the ITC can be used against the AMT, but it would have caused the PTC to be unavailable after the 4th year following placed in service for every project retroactively. So obviously that caused a lot of panic in the industry, and thankfully didn't make it into the final bill because the corporate AMT was eliminated from the final bill. So we had a couple of exciting weeks stressing out about these things, but if you'll move to the next slide, we can talk about what did happen. The final act, which was uncreatively titled the Tax Cuts and Jobs Act, the corporate tax rate is reduced to a flat 21%, starting with 2018. The big impact that this has on the wind industry and all industries is that the value of the losses created by accelerated depreciation deductions is reduced because those losses are offsetting, and I think there's always some confusion over the difference between a tax credit and the tax loss. A credit is a credit against your tax liability. A loss is a deduction. And the impact of reducing the rate to 21% is that the value of those losses, which are deductions, they're now offsetting income that would have been taxed at 21% rather than 35%, and so they're less valuable. This doesn't change the value of the tax credit because $1 of tax credit is offsetting $1 of tax liability either way. But corporate tax rate was reduced to 21%. As I said, the corporate AMT was repealed, which thankfully eliminated the 4-year limit on PTCs that would have been caused by the, I think that I should say the Senate proposal. And it also simplifies corporate tax, which is good. The new bill also creates a limitation on interest deductions, and this is, the details of these are beyond the scope of this presentation, but at a very basic level, it limits interest deductions to 30% of the sum of adjusted taxable income plus business interest income. This is going to impact projects with debt. There's just no way around it. And I think a lot of people, in particular, a lot of people who prepare financial models for projects are scrambling to make sure that their models incorporate this limitation appropriately for projects with debt. And going forward, everyone should make sure that they're properly accounting for this limitation.
PTI and ITC.
Yeah, that's an interest expense deduction limitation. So that applies to all projects with debt.
Yeah, regardless of what credit.
Next slide. One of the other major changes that the bill created was 100% expensing, which is really 100% bonus depreciation deduction for certain qualifying projects. Nothing in this bill is simple. The 100% expensing applies to any property that is placed into service after September 27, 2017, but only if it was acquired after December 27, 2017. And we'll talk about what that may mean. And then there's a phase down for bonus depreciation thereafter in the percentages shown. And those percentages are the percent of bonus allowable. So in 2023, you get 80% bonus depreciation and so on. And that's all based on when a project or when property is placed in service. As I mentioned, bonus depreciation, the new 100% bonus depreciation does not apply to property that is acquired before September 27, 2017, which the reason for that date is that's the date that the House version of the bill was drafted, was released. The bill doesn't say what it means for property to be acquired.
There's a footnote in there, right, that says.
Well, the effective date doesn't even say acquired by whom, but it does say that property will not under any circumstances be treated as acquired after a binding written contract was entered into. So there's a lot of uncertainty over this provision in tax equity structures because, you know, for example, in some structures, in some partnership flip structures, the partnership doesn't exist until funding. And before then, the LLC that owns the project is a disregarded entity. And an argument could be made that the partnership doesn't acquire the facility until the partnership is formed and there's a deemed transfer to a partnership. You know, I think that may or may not be the prevailing view. There's going to definitely be some need for additional guidance on these.
And I think also in the context of the portfolio structure, where the structure is set up so that the sponsor is contributing the project company to the partnership, whether the contribution of the project company to the partnership would be, whether it's acquired at that time as well.
Right.
So,
I think the more likely answer is that, especially given the reference to binding written contracts, I think
it's when the project company.
It's when the project company agreed to buy the components. But that, you know, more to come on that one. In addition, and this is maybe not as interesting for financing of new projects, but in all prior iterations of bonus depreciation, one of the requirements is that the person claiming the bonus depreciation be the original user of the project or of the property, which prevented sort of recycling of bonus depreciation for used property. That provision has been eliminated, and this may be of great interest to people buying and selling projects that are maybe out of the credit period. You know, subject to these phase down dates, you can now fully depreciate in year one a used project that is purchased by a different person. Next slide. Some of the other relevant provisions of the new bill, it eliminates the technical termination of a partnership rule. This rule, the rule used to be that if 50% or more of the interest in partnership profits and capital were sold in any 12-month period, the partnership was deemed to terminate and a new partnership was deemed to be formed. And the only downside of that was that depreciation periods for property owned by the partnership would restart. And that rule has been eliminated. And what this does is I'm not sure that Congress really meant for it to do this, but it makes it more difficult for developers to get bonus depreciation to investors, because we would often, or many investors would, investors who wanted bonus depreciation, and we'll get to whether that still will be the case, but would often take advantage of the partnership termination rules and structure to cause a termination for the purpose of getting the investor the bonus depreciation after the deemed termination. And that's no longer available because that rule's just been eliminated. There's also one of the big international provisions in the bill was a repatriation tax for certain foreign assets, and the details of this are well beyond the scope of this presentation, but essentially certain taxpayers are going to have to pay U.S. tax on assets that they have parked in foreign subsidiaries. That tax can be spread over 8 years, and there's a lot of detail, but the one impact of this provision is that some investors' tax appetite for tax credits will be reduced. And we've seen in the marketplace some investors backing away from these kind of investments as a result of that provision. A similar provision is what's been called the BEAT tax.
Base erosion and anti-abuse tax.
That's right. And this is a tax that is intended to prevent or discourage U.S. companies from exporting their tax liability by shifting what would be U.S. income offshore. This is often done, this is kind of well documented in the news. Many companies, for example, park their intellectual property in Ireland in a subsidiary there, and then the U.S. company will pay royalties to the Irish subsidiary for the use of that intellectual property. The result of that is what would have been U.S. taxed income is now taxed only in Ireland. And the BEAT tax is intended to discourage that. And what it is, it's inordinately complicated, but what it does essentially is it imposes a minimum tax on companies that do a lot of that kind of planning. And that minimum tax means that there's a possibility that the tax credits that are otherwise available with respect to renewable energy projects could be unavailable. And in an early version of the language, it could have entirely eliminated tax credits because they can't be used to offset that minimum tax liability. In the
investor wouldn't be able to use them. That particular investor would not be able to use them to offset its liability. It's not that the credits would be unavailable. It's that the value of that credit couldn't be used by those investors, right?
Yeah, and thankfully in the final version of the bill, there was some language added that it doesn't completely eliminate this problem, but it means that the worst it can get is that the ITC and PTC value could be reduced by 20%. And again, it's important that not all investors are impacted by this rule because not all investors do the degree of international tax planning and the kind of international tax planning that would put them in the soup in the BEAT tax. Finally, there's a provision in the bill that relates to accrual accounting and accounting for prepaid contracts. And without getting into really any detail, that could impact the usefulness of prepaid PPAs in renewable energy financing, which maybe isn't as important to wind as it is to other kinds of facilities, but one of the other changes that's relevant. Next slide. So that's kind of a summary of the tax law changes that were proposed and the ones that actually made it at a very high level. Now we're going to talk about what this means in terms of tax equity financing and in particular both new and existing tax equity financing documents. Next slide. So originally, and it was very common, and originally I'm dating back to maybe late 90s. It was very common for tax equity investors to bear the risk of tax law changes. The way these tax equity financing agreements often work at a very high level is that there's a set of agreements signed on day one that say, okay, if you're going to build a project, developer, and if you meet all of the conditions set forth in the agreement, on the date it's done, tax equity investor will put in money, and if it's a flip partnership structure, for example, they'll put in their money and become a partner for purposes of being allocated the credits and losses, and you're off. So in many years ago, there was a proposal that I wouldn't even call a proposal. It was really, I think Senator Grassley saying, I'm going to eliminate makers. Makers is a giveaway to corporate America, and we're not going to do it anymore. And I think it was really just a sort of get on the news, the evening news kind of a thing. But a lot of the investment community began to kind of be worried about that, and so we started negotiating stronger and stronger tax law change provisions and agreements. And so, for example, around that time, investors started getting worried about, well, what if I sign the agreement on day one and the law changes before the funding date and now I can't take advantage of these tax benefits anymore? Who bears that risk? And of course, anytime investors start asking that question,
the answer is the
developer should bear that risk. So we began negotiating provisions that shift the risk of changes to developers. That we also, would sometimes negotiate provisions for how the risk of tax law changes after funding is allocated between the parties. Beginning in late 2016, when Trump was elected, to many people's surprise, investors suddenly became very concerned about the now seemingly real possibility that the tax rate would be reduced, the corporate tax rate would be reduced, thereby reducing the value of the tax losses that flow through from these investments. And so we had another round of, I would say, negotiating more investor favorable provisions regarding tax law changes and proposed tax law changes. And again, we'll get into some of the details, but the trend, every time one of these happens, it's kind of a ratchet effect, is more and more risk gets shifted to the developer and away from the investor. So, next slide. Recent tax equity trends. So with that kind of very vague, a very broad background, I hope it wasn't vague. I didn't mean that. The provisions regarding tax law changes and proposed tax law changes in transaction documents, of course, vary greatly depending on the structure of the transaction, whether it's a sale leaseback or a lease pass-through or an inverted lease or,
solar,
mostly solar. What we typically deal with in wind is partnership flips. And even there, these provisions vary greatly depending on the specific terms of the flip, like, for example, whether it's a sign and close immediately, that obviously then that reduces the risk of, or maybe even eliminates the risk of tax law changes between signing and funding. So it's important when you're thinking through these issues to keep in mind the very specific structure of the transaction at issue.
I think the three, we just threw down three various approaches here.
I would say, first of all, this relates to proposed tax law.
Yeah, that's right. These are proposed tax law changes, and they're increasingly investor friendly if you kind of you march down this list. So the least investor friendly would be to, we're gonna negotiate what happens if and when a proposed tax law change occurs, or even a tax law change occurs. Second is, you update the base case model if and when it's passed, and then the protection for the investor is a cash sweep or an indemnity in favor of the investor to make up for any amounts that they may have overfunded based on the assumed tax rate at funding. And then the third, which is probably the most investor friendly, and this is whether it's an actual proposal, I think, or an assumed rate for purposes of the sizing in the base case model, is you incorporate it in the base case model with a supplemental funding if it's not agreed. And we'll talk a little bit later about kind of paying attention to what that outside date is if you're assuming, or if you're building in the potential for a proposed tax law change and you're assuming a rate that is lower than the actual rate at the time of signing.
Yeah, and this, it's important to keep in mind what this relates to, proposed changes, is, and this was kind of, gained importance when Trump was elected, is, okay, so what happens if it's time for closing and there's a bill in Congress to reduce the tax rate? What are we going to do about that? Are we going to ignore it? No. Or, we were closing some deals right around the election, and in some of those there wasn't enough time to actually deal with these in detail, and so we just put in if we'll deal with it if and when the bill passes, and we will agree to just sort of negotiate to make the economics the same with the new tax rate. I'd say the ratchet was in full effect in proposed tax law changes. And I think where things ended up in the market is before the bill passed, pretty much everybody was saying, all right, well, we're gonna run the base case model to determine the investor's funding amount based on the assumption that the rate is going to go down.
Yep.
And if it doesn't go down by whatever date the parties agree on, they'll put in more money, but we're going to size the initial funding based on that assumption. And many of those assumed 20%. And it actually went down to 21. So even if you think your documents dealt with this, it's important to look at everything, because some investors may owe a little more money just because the rate didn't go all the way down to 20.
And the date that money becomes due is going to depend on what the outside date is that was agreed for the for the true up.
And of course, as of right now, there is not a proposed tax law change, I think, under any definition that would take it to 20. So I think one theme that Chad and I discovered going through this is that even though tax law change became a big issue last year in particular in documents, and even though the bill has now passed, the fun is really just starting, and the tax law change issue hasn't gone away, and I think it's in fact going to ramp up, which we'll get into some of the details of that. But
yeah, the Tax Cuts and Jobs Act is the biggest Christmas present for tax lawyers and tax accountants for the next several years to come.
So that's kind of how documents dealt with proposed tax law changes. They also deal with actual tax law changes, and typically one of the conditions to funding is that any tax law change that happens before funding is incorporated into the base case model for purposes of determining the investor's investment. That's been fairly typical for a long time. I would say that documents vary pretty greatly regarding who bears the risk of tax law changes after funding. And I don't know that it makes sense to go any more detail than that. One issue that has been also addressed in transaction documents over the years is it's typically a condition to funding that the investor get a bring down of a tax opinion. So there's typically a tax opinion on the signing date that's a condition to signing. And then there's a condition to funding, which is a bring down of that tax opinion. And in some documents, that bring down is limited to changes in law. So in other words, developers had said, you don't just get to change your mind. You can, that condition is deemed satisfied if nothing is changed. But if there is a change, then you can get a new tax opinion. And change in tax law is often addressed in that language. Next slide. So with that kind of very general overview of what the import of these terms is, we'll talk a little bit about how they're defined. And, I think less really thought was given to these definitions earlier than later. But these are, the definition of proposed tax law change and tax law change are super important for reasons that will become apparent. In proposed tax law change, the kind of things that we frequently negotiate include, first of all, what kinds of proposals are taken into account. Some documents say, it's a bill that's reported out of a subcommittee. Others say it's a bill reported out of the Ways and Means Committee or the Finance Committee only. Some say it's any bill that's introduced. The range of language is very, very broad.
And I think it's fair to say that earlier on in the process, kind of the immediately post-Trump election, early on, the definitions tended to be a little bit broader in the proposed tax law change, no matter how hard investors or sponsors were fighting back against it. So you would have terms like white paper, and you made the comment earlier, what the heck is a white paper? Well, you know, your definition and my definition might be very different. But
a white paper is nothing.
But there it is. Yeah. I mean, it's in the definition of proposed tax.
Often it is, yeah. Yeah, and that's a very good example of investors, of course, would try to throw in the kitchen sink. Anything, you know, I saw some that said news reports, speeches. You know, what we, I think it's important if you're a developer to try to think, you know, what really is the purpose of this? It's, you know, if there's a serious proposal to change the law, then we should deal with it in our agreement. And some of these things you just can't argue are serious proposals to change the law. The way that, I'm kind of skipping ahead a little bit, but the way we dealt with that issue in many agreements is adding a qualifier that basically says, whatever among that list we're talking about, it's only things that are reasonably likely to be enacted that you take into account. And I think everybody recognizes that's very loose language that can be fought over, but at least it puts some brackets around, you know, not every crazy thing some crazy representative says in a news interview is a proposed tax law change.
Yeah, and I think if there's a theme to this, it's for sponsors and investors alike, but I would say sponsors especially, is make sure that when you're looking at these provisions that take a little bit of time to get smart on the legislative process. Really understand that, you know, things like each Congress has 2 sessions, right? And when you're talking about the first or the second session, you're talking about 2 completely different dates. And how these potential changes or how these proposals actually come to be and how they could die. I think that's both are important to look at, but
right.
I think we should move on.
So the other thing, and this will be important in tax law change also, is what scope of changes get included. Is it any change that would impact the financial results to the investor, or is it just changes to the PTC and tax losses? The ratchet was kind of in effect there too, and everyone can guess which way it ratcheted. Tax law change definition. Again, you got to think about, next slide. Again, it's important to think about what purpose, for what purpose is this term being defined? And that relates to, you know, how the risk is being borne between the parties in the agreements. And I'd say on the developer side, what you want to be thoughtful of is just, this should include actual like changes to the law. And, you know, the things we negotiate are kind of similar to proposed tax law change. Obviously, it always includes legislation that's passed and signed. Some people tried to get it to include legislation that's passed and likely to be signed. Regulations are often listed here. It's important, just like Chad said about the legislative process, it's important to understand the Treasury Department regulatory process, because proposed regulations may not actually be the law. There's lots of proposed regulations.
Private letter rulings.
In the next category, IRS releases, sometimes we see definitions proposed where it's just that, it just says any release by the IRS. And again, it's important to understand that process, because revenue procedures, revenue rulings may have general applicability, but private letter rulings are issued to
a taxpayer
and are not generally applicable, and also are heavily redacted. So often you have to kind of guess what's even going on in the ruling.
I think the next one is important too. When you're talking about court opinions, that there's a difference between a legislative change in the law or a change in the regulations. It's very easy to see, but if you've got a case that's coming up for a taxpayer in the Fifth Circuit and your project is located in the Ninth Circuit, and really there's no precedential value for a decision in Chicago, on a project in California or somewhere else in the West, then one of the things to be thinking about is whether you want to push hard enough to ensure that only courts whose decisions are binding on your project should be included in the scope of tax law change.
There's also the question of, and again, all of this is really just thinking about how these things work more than anybody really ever wanted to, but there's often references to executive orders and other executive releases that you just have to think about what they really mean. And as with proposed tax law change definitions, a couple of other things to keep in mind are, oh, we skipped to the next slide. We didn't mean to do that yet. Are whether the definition is limited to changes that directly impact the project or the tax credits or depreciation, or whether it's anything that might impact the economic benefit to the investor. A really great example of this is the BEAT tax, because obviously it has nothing to do with anything in the U.S., much less an investor's investment in wind farms. But it may cause that investor to get less value out of the tax credits. And if your definition of tax law change or proposed tax law change was very broad to include anything that might limit the value of these benefits to this investor, the change or proposed change to the BEAT tax could have given the investor an out to funding, arguably, even though it had nothing to do with any of this. It really is just...
And how to quantify that or prove that there actually was an impact is a difficult question, I think.
Right. And that investor may have a bunch of other investments in tax credits, like rehab credits and new market tax credits or other U.S. tax credits. Query which credits are less valuable if your aggregate use of credits is reduced. They're going to argue it's the ones they haven't paid for yet. So that's something to think about. Next slide. These issues also come up in most documents have a term called fixed tax assumptions, and these are assumptions that are made for purposes of calculating the investor's investment that are assumed to be true unless they're untrue because of something the developer did wrong. And they're often things like the partnership will be respected if it's a flip partnership structure, investor will be treated as a partner, the allocations will be respected, the project company will be treated as the owner. And it's very important to look at these documents and ask, well, what happens here if the law changes? Next slide. So what's the status of all of this after the tax reform bill is passed? And as we alluded to earlier, this is not going to end the consternation over tax law changes or proposed tax law changes. I think if anything, it's going to heat up. First of all, there's a lot about the tax reform bill that remains unclear. For example, we talked about it's not really clear what acquired means for purposes of bonus depreciation. There's going to need to be some additional guidance on that topic, which may include proposed guidance, and it may include, somebody asking for a private letter ruling, and the question will become more important of whether a private letter ruling can be a tax law change or a proposed change. Another open question is how bonus depreciation is going to impact BRO issues. I'd say on that, bonus depreciation, if an investor wants it's something that has to be modeled. There's a lot that's uncertain about exactly how it works. I think a lot of people who have to put these things into models without knowing exactly what the rules are scrambling to try to figure all this out. it's just something that's going to need to be worked out over the coming years. Another is how the BEAT tax will impact investors. I think a lot of the big investors are still working out internally how much risk they have of the BEAT tax applying. And different investors have different sort of offshore tax planning profiles, and these provisions are going to apply differently to them. So there's going to be years of regulations, technical corrections, IRS rulings, cases, and I would say that the provisions and agreements may not change much. They'll certainly the war between developers and investors to allocate this risk will continue, and the ratchet doesn't usually work the other direction. So there's a lot that's unknown, and all of these issues and provisions are still very, very relevant. And if that's it. If people have questions,
Catherine, I guess we'll turn it over to you for a few minutes of Q&A.
Thank you so much. So we'll now get started with the Q&A section. Just a reminder, you can type your questions in the Q&A box in the lower right-hand corner of your screen. We'll make sure to answer your questions if time permits. So we'll take a few questions right now. Let me take a look. And thank you again, Kevin and Chad, for your presentation today.
Our pleasure.
All right, so we have a lot of questions here. Let's see. Well, Lee asks, do the rules on PPAs also apply to 467 rents?
Well, so prepaid lease agreements, yes, they might very well apply to those. Yeah. That's a short, sweet answer. And I would say with respect to these questions, the details of a lot of these new rules is, in addition to not being really fully understood or fully fleshed out, it's kind of beyond what we plan to discuss today. But I would say that, yeah, for prepaid rent, you also have to look at the changes to 451 that were created by the bill.
Okay, perfect.
Those rules apply to any transaction where the tax treatment differs from the book treatment.
And so we have two more questions just kind of going over, is specified credit relevant after 2017, you would say?
I'm not sure I fully follow that question.
They asked, is specified credit relevant after 2017? If it's, if you, we could move on if that's.
Let's move on. I don't fully follow that.
Okay, let's see. A lot of these are really long questions.
Probably posing scenarios that are relevant to.
Yeah. Let's see. Let's just ask one last one. How do you treat bonus if a portion of the system is placed in service in 2017 and a portion in 2018? And we'll leave that as the last question.
Yeah. So that depends on. There is a whole 50 years of authority for what constitutes, quote, property for depreciation purposes. And the question is, first you have to figure out what the property in question is, and then you have to figure out when it was placed in service. And, there are cases having to do with aircraft maintenance, for example, where the question is, if you replace the engines on an airplane, is it now a new airplane that can be newly placed in service or not? And not to get into too much detail there, but it's fairly clear with wind that each turbine, together with its pad, tower, nacelle, blades, is a property that is separately placed in service from all the other turbines in the wind farm. So any turbine that's done and capable of operating and placed in service in a particular year is eligible for whatever bonus is available for property placed in service that year. And you really, this can be a really tricky analysis with respect to solar, for example, because if you have a solar array that has 10, can be divided into 10 units that can be operated independently, each of those units might be a separate piece of property that's placed in service. But that's the kind of issue that we wrestle with a lot, and you should get advice.
How does that, just as a follow-up on that, you know, we now have the September 27th date. That kind of makes it even more relevant, where we've got a before and after September 27th for
and the added wrinkle of what does it mean for property to be acquired.
To be acquired.
Yeah,
that's right. So good question.
Thank you so much. I'm reading a lot of great questions here. Fortunately, we don't have time for all of them. But if you'd like to contact Kevin and Chad, please feel free to do so with the information on the screen. They both will also be joining us at Wind Finance and Investment Summit in February. So if you'll be at the event, make sure to look out for them and connect, say hello. And that's all we have time for today. Thank you so much to Kevin and Chad, and to everyone who tuned in. As a reminder, you will receive an email with the recording of this webinar within 24 hours, so you can watch this webinar as many times as you'd like to take it all in. And before you go, make sure to sign up for Wind Power Finance and Investment Summit that's coming soon to San Diego. Please feel free to register at www.infocasinc.com/win. Again, that is www.infocastinc.com/win. And thank you all again. I hope you guys have a great day, and we'll catch you around next time.
Thanks very much, Catherine. Have a great day.